Hello, everybody. I'm back on my own computer. That's all I got done today was getting my computer set back up. Well, and, harvesting all the dockets from today. That's an important job. That's how I keep bringing you new stuff. Ava, honey, I still don't have the treats in here. But you know what? I don't know what this is. Maybe it's treats. Let's find out. It is not treats. It's treats for me. Oh my gosh. 52 pods of coffee. Oh. Oh. From Amanda, Adriana, Amy, and Palmyra Productions. Thank you so much, you guys. Oh my gosh, I have coffee. Thank you, thank you, thank you. Sorry, Ava. I will have to get hers. Whoopsies. I dropped them off the edge of the desk. They're retrievable. Oh my goodness, I'm going to have to text him and thank him. I bet that's why he tuned in last night. I bet he was waiting to see if I opened it. He works so hard. So it's always a treat when he gets to stop by. Hello, Nana Laura. Hello, Linda Applegate. Hello, Jerry Matthew Boyd. Hello, Charlie. Oh, that was a big yawn. Oh my goodness, it's a big yawn from baby girl. Yeah. She got in a little argument with something. I'm thinking it was a neighbor dog. So she's got some iodine on her neck right now because I found a abrasion, we'll call it. Hello, Spider-Man. Hello, Eileen Carlin. Hello, Sandy Hurd. Nope. The defendant changed her mind. You just wait. You'll see. Exactly. Yes. I love that. Yes. And she sounds like every HOA's dream. I seem to have missed a name. I see a hello Jennifer, but I don't see a Jennifer in my chat list. Well, hi Jennifer. I see the comment, but I don't see the Jennifer. Maybe she's hiding from me. I hear Earl. Earl is making himself quite well known. All right. So I had to do all the editing on my old laptop because my computer wasn't set up yet. Oh, would you stop? I already told you I don't have treats in here. So I did all of the editing on my old laptop and then I had to transfer it all to this one. So let's hope when the kitties helped, when I'd get up to go to the bathroom or get something to drink, and I'd come back and I'd find the sound muted or the screen moved or, things like that. Let's just really hope that it all comes together right now. This is more closer to its true color. It still looks more blue. So hold on. No, that's not the button I wanted. Come on. Hold on, I can do this. I can do this. Okay, there we go. So it changes. That's more its true color. Like the lighting that I have on right now, but that makes my face look terrible. So, so you guys it can look blue. It can look blue. It's okay. It's gray to me. I love you so much. I love you so much. Hello, she's a maker, sweetie. Oh, I'm so jealous. Actually, not really, because my lawnmower isn't put away. And I would have to go put it on the porch myself, which I mean is fine if I have like a half hour to do so. But in the rain, it's not so much fine. Oh, look at Earl rolling around on the floor back there. Hi, buds. Yeah, you want this box? You want this box? Palmyra Productions. He says he doesn't buy kitties presents, but he doesn't know how much y'all love boxes. No, hubba hubba. Yes, he is. He's trying to get everybody's attention because he's an attention hog. All right, let me see where I put up there. I found it.
Mr. Wells?
Yes, ma'am.
Okay, so let me look at one thing. All right. 2 charges from January 9th of 2023. Do you even remember them? Over on Woodland Street and Northeast 12th in a Chevy Silverado operating an unregistered motor vehicle was the first one. Do you remember those tickets?
Yes, ma'am.
Okay, on the operating the unregistered motor vehicle, the fine range is $1 to $200. Court costs on that are $131. Would you like to plead not guilty because you want to hire an attorney or have a trial?
Not guilty. I mean,
Not-
no contest, right?
Yeah. Well, yeah, I can't give you advice. So not guilty means you want to have a trial. or that
Okay,
you need
guilty.
to consult an attorney.
Guilty.
Guilty means I did it. I don't need to even hedge. I was guilty. No
Yes.
contest means you feel like if you had a trial, you would be found guilty. So how do you choose to plead?
Guilty.
Okay, on your guilty plea, fine and court cost is $242 with $150 jail credit. So
I can't get the $300 jail credit.
why would you get 300 jail credit when you got there last night, 4 hours before the end of the day? You hadn't even been there 24 hours.
Oh, I thought I got here like at 6, then at 12 it starts another day. Okay.
Good ask.
I just asked.
Okay, to driving while licenses, you might as well ask. All I can say is no.
Well, I'm not gonna get fed, you know what I mean?
Well, you're still gonna have to appear no matter what tomorrow when you
Understand.
get out. So to driving while license is invalid, that fine range is $1 to $500. Court costs are $131. That one has an extra consequence. If you continue to drive with an invalid license in the future, it can be filed as not a Class C misdemeanor, a higher charge. To that charge, do you want to plead not guilty because you want to hire an attorney or have a trial?
I wanna get out today, not guilty.
You're getting out today no matter
Okay,
what.
okay, not guilty.
Not guilty? You think you have a valid driver's license?
Oh, no, I'm in guilty, I don't got one.
Okay, on your guilty plea. Now, if you change your mind when you come see me tomorrow, you let me know. With
Why
the
do you say $1 to $500? You know, or can
Because
we talk?
that's the fine range. If you had a trial and you were found not guilty, you don't owe anything. If you had a trial and you were found guilty, then based on the evidence, that's how the fine is assessed. But in the interim, when you're trying to decide if you want a trial or not, we set these fine ranges, we set a fine and court cost that's somewhere in the middle. So
Okay,
it's $469 if you resolve it without a trial.
okay. Thought we could lean more toward the $1.
You like to negotiate. Well, I don't negotiate. So do you
Okay,
plead
that's
not
fine.
guilty, guilty, or no contest?
Guilty.
So on your guilty plea, finding court costs is $469. I know how you work. Okay, so $319. So let me figure out what your total is so you can know exactly. Oops. So $242. Do you tell them at Walmart that you want a deal there?
All the time.
Huh?
When I show, yes.
Do you really? That doesn't work at Walmart. Okay, when you appear tomorrow, the balance is $411. Yahida, is that right? I don't want him to say, well, she told me one thing. I mean, 242.
And you're giving them 1 day credit?
Yep.
Let me make the math.
So it's 92 plus.
Can I do a day and
Oh,
a half?
it's 411. So no, we don't do half days. So you're gonna appear tomorrow, be here at 1:30 for a 2 o'clock hearing. If you want to ask for community service, bring proof of income, proof of expenses. I'm looking at whether or not you get HUD housing or any kind of government aid as to whether or not I allow community service. But if other than that, we could set a payment plan if you work.
Okay.
Okay, but if you fail to appear, they'll turn into capious warrants. That's how you're stuck in the jail.
Okay.
Okay, I'll see you tomorrow. Deputy in the back will give you a map with directions.
All right, thank you.
Dana Cooper. Okay, Ms. Cooper, first things first, you pled guilty back in 2024 to a parking disability placard and you just never paid it, but you are time served on that, okay? Because of your time at Potter County. Boy, you sure were there a long time. Were those capious warrants from the JP?
I don't know.
You don't know? Okay, so let's talk about your Class C misdemeanors in my court. From March 19th of 2025, over on Southwest 3rd in Tennessee in a Dodge Durango and no driver's license. Fine range is $1 to $200. Court costs are $131. Do you want to plead not guilty because you want to hire an attorney, have a trial, or bring me your driver's license?
I never got my driver's license from Texas. I'm from Ohio and I have my license in Ohio. I just never got it done, transferred to Texas.
Okay, so do you want to plead not guilty, guilty, or no contest?
Guilty, I guess.
Fine and court cost is $260. your time served. So then April 1st of 2025, over on Amarillo Boulevard, unrestrained child safety seat violation, fine range on that is 25 to 250. Costs are 184. Do you want to plead not guilty because you want to hire an attorney or have a trial about that?
Guilty. I
Okay.
don't understand that, but guilty, cause
Somebody's, a child was in your car and apparently they weren't buckled up pursuant to the law is the allegation.
okay, but I did have car seat. It was it was the improper car seat.
That's
Yes,
right. They're really specific about what's required.
Yes, ma'am.
So
Yes,
then you
ma'am.
got a
Yes,
speeding ticket too, 48 and a 35. How do you choose to plead?
yes, ma'am, guilty.
Okay, finding court cost is 306 because of all that time at Potter County, your time served, okay? And your time served on the unrestrained child safety seat. Lastly, a dog or an animal named Phoenix, animal at large, got out. Did that happen?
Right before I came to jail, so I haven't had a chance to even. I
Well,
haven't,
do you want to plead guilty or no contest and be time served, or do you want to come see me on it?
I wanna do time served,
Okay, so how do you plead? Either guilty, not guilty, or no contest.
guilty, time served.
Bonding court cost is 134. So for you, this is a fresh start.
Amen.
No warrants. If you get tickets, don't let them go to warrant. You don't want to be in the jail on Class C misdemeanors.
No, ma'am. No.
Okay, thank you. Can return to your pod.
So do I get to go home today?
You'll be released as long as you don't have holds elsewhere.
Amen. Thank you so
Thank
kindly.
you. Bye-bye. Olivia Ramirez.
Get to go out. Thank you.
Okay, so a lot to talk to you about. I'll talk to you about the capious warrant after we talk about the charges that are at standard warrant. From May 7th of 2024, you pled not guilty from the ticket you got on the day that APD brought you in, and then you missed your next court date. So no liability insurance, fine range is 175 to 350, court costs are 131. Do you want to plead not guilty because you want to hire an attorney or have a trial?
No, ma'am.
How do you plead?
Guilty.
Finding court cost is $365 with $300 jail credit. You still owe $65. To no driver's license that day, fine range is $1 to $200. How do you plead?
Guilty.
Finding court cost is $225 on that. Your time served. Then no driver's license from April 27th of 2024. Let me be sure these are, yeah, April 27th, 2024, over on Jim Lake Road. How do you plead?
Guilty.
Finding court cost is $225. Time served on that. Let me put this over here. Okay, then June 16th of 2025 on 51st and Southwestern. Driving while license is invalid. That fine range is $1 to $500. Court costs are $131. Do you want to plead not guilty because you want to hire an attorney or have a trial?
No, ma'am. Guilty.
Okay, finding court costs is $469. $300 jail credit. You still owe $169. And then no liability insurance. That fine range is $175 to $350. Court costs are $131. How do you choose to plead?
Guilty.
Finding court cost is $400. Again, $300 jail credit, $100. So let me see what your balance is. So you owe $269 plus 65 plus your balance as your capious, which is 30. Okay, you had to correct me if I'm wrong. I show that her total is 364. So I'm going to release my hold on you to appear tomorrow to talk about that you still owe money here, okay? And
I have a couple
understand-
questions for you.
Huh?
I have a couple questions for you.
Okay.
So being with that, like, is there any way possible, or do y'all have any programs where I can get my license in the state of
Well,
Tennessee?
you're gonna have to work with the Department of Public Safety to see what's the story on your license. Now, everybody's a little bit different. It could be that you, with these two new no liability insurance convictions, they're for sure going to make you have liability insurance before they give it back to you.
I've never
You
had
have
that.
to go figure out what your driving record is and what they say to get your license back.
Okay, so if I go there, I won't be back here.
No, and not unless you have warrants other places in the state.
No, ma'am.
So you might as well start, but the first step is to be here tomorrow at 1:30 for a 2 o'clock jail release hearing. Yahada, did you confirm the total?
Yes, ma'am, it's 364.
Okay, so we'll be talking about how to pay 364. I'm not saying you have to pay it. If you can pay it, you don't have to appear for the hearing, but if you can't pay it, don't miss that hearing, okay?
Yes, ma'am.
Okay, I'll see you tomorrow. The deputy in the back will give you a map with directions to the courthouse.
Yes, ma'am. Thank you.
Ms. Patterson, go ahead and come up. Ms. Patterson, the charge before the court is called drug paraphernalia possession. The fine range on that is $1 to $500. It's regarding a scale. On that charge, are you wanting to plead not guilty because you want to hire an attorney or have a trial?
What do we have to do in the trial?
I'm sorry, say that again.
What do we have to do in the trial? I'm like, this is my first time ever being in trouble, so like, I'm like, yeah.
Okay. Well, I want you to feel comfortable with every decision you make. So not guilty means that you want to come and appear pursuant to a bond, and I would give you a personal bond. You don't have to call a bail bond company. As you're leaving the jail, you sign that document that is your promise to appear. You come on that date and time to the courthouse, which is at the police department building. You know where that is?
Yes, ma'am.
And that's where I give you all information about how to have a trial. If you're going to represent yourself, how to represent yourself, how to discover the state's evidence. But if you don't want to go through the trial, if you want to waive that trial, you have the ability to do that today. And then you would plead either guilty or no contest, saying, I am guilty of having a scale that is drug paraphernalia. And that would mean that you have to come and see me tomorrow to talk about a balance of 231.
I can, guilty,
Say it again.
guilty.
Okay, so on your guilty plea, fine and court cost is 531. So that means you have $300 jail credit and you owe 231. So the deputy in the back's going to give you a map with directions to my courthouse. And that means you got to be here tomorrow at 1:30 for a 2 o'clock jail release hearing. If you fail to appear, I issue a warrant for your arrest. So don't miss that jail release hearing tomorrow, okay?
Is there a way if I had to pay that, is there a way I could do community service or anything?
Bring me proof of income, proof of expenses, so we can explore that possibility.
Okay, cause the money that was in my bag was my rent money and stuff that I
Yeah.
had schooling and.
What do you do for a living? Because also we can set a payment plan. The payment plan, it's just if you fail to, I don't expect you to pay it in full. I want you to pay your rent.
Right.
And then, but don't miss that hearing tomorrow, because I'll talk to you about a payment plan too, if you don't qualify for community service.
Okay, that's fine.
Okay.
I just say I work at JBS and then I do Chef Smart, which is PepsiCo and Frito-Lay. Those
What are
two-
your hours at JBS?
40 hours.
But what are the times that you work? Which shift?
I work a shift from 4:30 in the morning to 3 in the afternoon.
Ooh, well, are you working tomorrow?
I'm out of work for a month because of my 3rd-degree burn. So
Okay, so you can appear at my courthouse then tomorrow, then you're not gonna miss work for that. Where'd you get burned?
it was a grill propane blow up.
But it wasn't work related?
No,
Oh,
ma'am.
ouch.
I was the first one to survive a propane grill blow up.
Oh my goodness.
A propane grill blow up? First person to survive it? You better kiss that angel on your shoulder.
Did that happen on July 4th or something?
No, ma'am. It was I think it was last month on the 7th.
Oh,
And I've been in the hospital ever since, and then I literally just got out of the hospital when I was at work and they arrested me.
oh. Okay. Well, I'll see you. You should be processed out today. I'll see you tomorrow at 1:30 for a 2 o'clock jail release hearing. Deputy in the back will give you a map with directions.
Yes, ma'am. Thank you.
And bye-bye.
Next matter the court is going to take up is a status conference in state of North Dakota versus Theresa Bush, 02/2025 CR 28. Attorney Duffy appears on behalf of the state. Attorney Barkas appears on behalf of the defendant. The defendant appears personally in court with her attorney. Like the last case, this case is set for trial to start tomorrow at 8:30 in the morning. Both parties were ordered on May 23rd, 2025 to prepare proposed jury instructions and file a legal memorandum at least 14 days before trial and to identify exhibits and the like. What's the status? Well, first off, neither party did that. Mr. Barkas, what's the status? Are we having a trial tomorrow?
I don't believe so, Your Honor. We do have an outline to an agreement. Obviously, it's a joint recommendation, but both parties would agree to no jail time for for my client. And then we have differencing on how this would.
Say that last part. I didn't quite hear you.
I'm arguing for a deferred. Ms. Duffy is not.
All right. Ms. Bush, is that what you anticipate?
Yes, sir.
All right. Were you present in court when your rights were read to you?
Yes, sir.
Do you understand your rights?
Yes, sir.
Do you have any questions about your rights? My understanding is you intend to offer a guilty plea to the charges that stands, and then the attorneys are going to argue about differing outcomes. Is that true?
It's true.
You're going to have to speak up. There's that little hockey puck looking microphone in front of you. We want to make sure we pick up what you're saying, okay?
Yes, sir.
All right. So I asked you if your understanding is you were going to plead guilty to the charge that's in front of you, and then the attorneys are going to argue for something different. Is that your understanding?
Yes, sir.
All right. Do you understand that you have the right to plead guilty and you have the right to plead not guilty?
Yes, sir.
Do you understand that by pleading guilty, you're waiving the rights that were read to you before, including the right to a trial of any kind, to a judge or a jury? In your case, for 6 persons in a jury trial to unanimously find you guilty before you can be found guilty, you're waiving the presumption of innocence. You're waiving the requirement that the state prove you guilty beyond a reasonable doubt. You're waiving the right to confront and cross-examine witnesses against you, the right to remain silent or to testify for yourself, and to use the court's subpoena power to have witnesses appear for you. You can always present evidence at a trial. You understand that you're waiving all of that. You're waiving the right to any and all defenses that you could have had. You're waiving any and all non-jurisdictional defects in the case if there are any, and you're limiting your ability to appeal the case if you enter an unconditional guilty plea. Do you understand all of that?
Yes, sir.
Do you still want to plead guilty?
Yes.
I didn't hear you.
Yes, sir.
Has anyone forced you, threatened you, or coerced you, or made any promises to you in order to get you to plead guilty? You're shaking your head no, and you kind of mouth the word no, but I need to hear it. I'm sorry.
No.
All right. Has anyone told you that you have to plead guilty?
No.
Is this what you voluntarily, knowingly, and intelligently are doing?
I really didn't want to.
What's that?
I really didn't want to plead guilty to something that I didn't do. But the only way that I was told that I would be for sure not to get jail time is if I did. Otherwise, it was a 50-50 chance that I would go to jail and that they would argue for more than 10 days. So I feel like I really don't have a choice to stay out of jail to make sure that I can stay home with my kids. If I plead guilty, so that I didn't have to do jail, and that was the only thing because I didn't do it, and so I.
All right, so
that's-
I'm going to stop you here, and I want you to understand you have the right to plead guilty. Here, there is no plea agreement. It sounds like there's going to be a joint recommendation for no jail and an argument about the way in which the sentence works. Understand that I'm free to impose whatever sentence I want, and it could include jail up to the maximum penalty. Here, this is a disorderly conduct. The maximum penalty is 30 days in jail, and there is no minimum mandatory penalty. So I'm free to impose whatever I want. It sounds like when there's an agreement, generally I follow those agreements. Sometimes I do things that are different, but you have the absolute right to have a trial. And I want you to understand that no one, including me, I'm not going to allow anyone to force you to plead guilty. So if you don't want to plead guilty, we'll have a trial, but it starts tomorrow. And you understand that if a jury finds you not guilty, then you're absolutely not guilty. You walk out of the courtroom. If a jury finds you guilty, then it's my job to sentence you. And the attorneys would make an argument. It sounds like under those circumstances, the state might argue for jail, and your attorney, of course, would argue for no jail. But I'm free to impose whatever I want, whatever I think is appropriate between the minimum mandatory penalty and the maximum penalty. You understand that?
Yes, sir.
So the choice is yours on whether you want to plead guilty or not guilty. If you plead not guilty, we will just have a trial tomorrow. If you plead guilty, we won't have a trial tomorrow, and I'll deal with sentencing right now. What do you want to do?
I'll stay with the plan.
And the plan is?
I'm gonna plead guilty.
All right. Do you need any more time to speak with your lawyer about your rights, your defenses, if any, your plea that you're offering today, and the potential for the court to sentence you?
I don't need any more time. Thank you.
Are you pleading guilty because there's a plea agreement in place?
Yes, sir.
And the plea agreement is a joint recommendation, that's your understanding?
Yes, sir.
And you understand, or joint recommendation for no jail and an argument about whether you should have a permanent conviction or a deferred, right?
Correct.
Okay, and you understand that, again, even today, by pleading guilty, I don't have to follow either party's recommendation. I can do anything from the minimum mandatory penalty to the maximum penalty. You understand that?
I understand.
And you still want to plead guilty?
I will.
All right. You recall a time at an earlier appearance where the nature of the charge was explained to you, the maximum and minimum possible penalties were explained to you, the potential for court fees was explained to you, the potential for restitution was explained to you, the potential for adverse immigration consequences was explained to you, and the potential for other adverse collateral consequences was explained to you. Do you recall that hearing?
Yes, sir.
Do you need to be reminded of what happened at that hearing, or do we need to walk through those issues?
No, sir.
All right. And so you are charged in a single count information with disorderly conduct offensive condition. In that charge, the state alleges that on or about July 4, 2024 in Barnes County that you committed the offense of disorderly conduct, Stacey McInnes, or in reckless disregard of the fact that Stacey McInnes was harassed, annoyed, or alarmed, that you created a hazardous or physically offensive or seriously alarming condition by displaying a taser and pointing it at Stacey McInnes, an act that served no legitimate purpose. To that charge, how do you plead, guilty or not guilty?
Plead guilty.
Ms. Duffy, a brief factual basis, please.
In this case, Your Honor, back on July 4th of 2024, the Barnes County Sheriff's Office was dispatched to Sibley on a report of a juvenile that had been assaulted while riding a four-wheeler. Upon arrival, Deputy Budke spoke with the individuals involved, which included Ms. Bush, Stacey McInnes, and then there were several children around as well. Through the course of their investigation, they learned that there was a football that had been being thrown. The football hit the person driving, the juvenile, I believe, that was driving the four-wheeler, and this was upsetting, it appears, to Miss Bush. As a result, Miss Bush and Stacy McGinnis, who'd be the parent to one of the other children that was there and involved, Miss Bush and Miss McGinnis were going to have a conversation, it appeared. At one point during the conversation, Miss Bush got upset about the entire incident, basically, and had pulled out a taser and displayed it at Stacy McGinnis. This was very alarming to Stacy McGinnis. She was scared. She didn't know what Miss Bush was going to do at that point, as they had just intended to talk about Ms. McGinnis had intended to just talk about the behavior that the kids were kind of having a spat about. The state's position is that the displaying of the taser and the conduct that surrounded that was an act that served no legitimate purpose.
Ms. Bush, is that essentially what happened?
Not quite. They also took the keys out of my daughter's four-wheeler and held her detained as they continued to hit her. And that's not in there either. And when I was sitting down there, I was sitting down there with a pink little stun gun, and they came to me. I didn't go to them. They came to me, and I was sitting there by myself. And my father-in-law had been choked by the guy who lived right down the street, like 2 houses from where I was sitting, which was the reason I had the stun gun on me. And so it wasn't, and we were talking. I did not yell at Stacy. I asked her, I said, this is the reason I wanted my kids to have a stun gun, is because we had been harassed in the town for a couple of years. And then I put it right back down, and then I talked to her and I told her to leave. And it's on, when we did the restraining order, it's on there that I had to ask her to leave multiple times. It wasn't a stun gun. She describes a taser. I didn't have a taser. I can't have a taser. I can't have anything that you have to register for. So it was just a little pink stun gun.
All right, so
And so it wasn't for not a legit purpose.
what is being alleged is that you displayed what the state calls a taser, but you're saying is a stun gun.
And Officer Emma says that based on her thing, she knew that it was a stun. I showed it to her that day.
Oh, okay. So what I want to make sure I understand, you're not disputing that you displayed a pink stun gun.
Right.
Okay. And you are disputing some of the facts and circumstances that surround the display of the
Right.
stun gun. Okay. Do you understand that what you're alleging is essentially a self-defense claim or a defense of others claim? And that's a trial defense that you certainly can raise at trial. And if you raise it, the state has to disprove it beyond a reasonable doubt. But by pleading guilty, you're waiving those defenses.
I don't want to. I would rather go to trial.
You'd rather go to trial.
I would rather not plead guilty to something that I don't feel like I deserved.
Mr. Barkus, do you want to take some time to speak with your client, or are we just going to withdraw the plea and start at 8:30 tomorrow?
Let's give me some time, Your Honor. And you
All right.
call my cases last.
I will call your cases last. So we will go off the record in this case. Ms. Bush, you can speak with your attorney, and we'll take this back up later. All right, the court is going to recall State of North Dakota versus Theresa Lee Bush, 02-2025 CR28. Ms. Duffy appears on behalf of the state. Mr. Barkus appears on behalf of the defendant. The defendant appears personally in court. Ma'am, this was scheduled for a status conference. Jury trial was scheduled for tomorrow. When the case was called originally, your rights were read. You said you understood your rights. The court walked through that. The court was informed that you intended to offer a change of plea from not guilty to guilty, and then some argument about sentencing. Somewhere in the process there, you expressed some reservations about pleading guilty, and so the court put the case in recess and gave you some time to speak with Mr. Barkus. Have you had enough time to talk with Mr. Barkus?
Yes, sir.
What's the plan?
I would like to go to jury trial.
All right. So any previously entered guilty pleas are vacated and not accepted by the court. So that leads us to the next issue. Neither party followed my pretrial order. So at this point, jury instructions aren't prepared. The court hasn't addressed any other concerns. I know from the previous disorderly conduct restraining order case, there's digital media that I reviewed a year ago when this happened. Neither party has presented that to me to address whether or not there's any 403 objections in it. What should I do about both parties' non-compliance with my pretrial order, Ms. Duffy?
In this case, Your Honor, I anticipated today's hearing going a different direction. That doesn't excuse me not doing the pretrial memo. If Mr. Barkus is ready for tomorrow, I can get ready for disorderly conduct trial in a week. The states, or in a day, I mean, the state intends on, I'm aware of the video. I intend on simply providing testimony as evidence. I don't intend on providing video. There's not a lot of witnesses in this case, and if we proceed tomorrow, the state will be ready.
Mr. Barkus?
Your Honor, I'll echo what Ms. Duffy said. There is an additional issue. It was also my understanding that we were going to have a change of plea today. That was communicated to me by the defendant. The defendant didn't say anything until we got here today. I communicated that to Ms. Duffy. In addition, during the recess, we did have a conversation. At that point, she is unhappy with my services as an attorney and fired me, and I believe would want new counsel. Because I think that this case, deserves that. I think she should have adequate counsel, and I don't think she believes that I can do that at this point.
So if the intention to offer a guilty plea was communicated to you, we had court back on May 20, 2025. That's when I issued my pretrial order, or at least I said a pretrial order would be forthcoming. The court on its own set a status conference, so we didn't call in a jury panel that was unnecessary for tomorrow morning. And now what you're telling me is because the court on its own had to request a status conference. You didn't request a change of plea hearing. And now we're here this morning addressing this issue. And now you're saying that there's a motion to withdraw forthcoming and new counsel needs to be appointed. New counsel certainly isn't going to be appointed and ready for tomorrow. I'm more than a little frustrated that I have a jury panel that now has been waiting and has been told they need to show up tomorrow at 8 o'clock in the morning. And it's now almost noon the day before, and they still think they need to appear tomorrow. So they're scrambling to get daycare, they're scrambling to take care of their jobs, to find childcare. The reason I make parties do things 2 weeks in advance of trial is so I know whether the case is going to go or not. And here we're the day before, and it's fine, ma'am. I'm not upset. If you want a trial, we'll have a trial. There's no concerns there. I don't want you to misunderstand. But what I'm frustrated about is I have 27 jurors that are expecting to be here tomorrow. So now the clerk's office has an additional obligation to scramble and contact all those people and tell them don't come. The court is going to need to address some issues. This isn't something that should be happening last minute in all of these cases. That needs to stop moving forward. Tomorrow's case will be continued one term. Mr. Barkus, are you moving to withdraw?
Yes, Your Honor.
Ms. Bush, is that what you want?
Yes, Your Honor.
You understand that I might give you an opportunity to have a new public defender appointed once, but it's your obligation to stay in touch with attorneys. It's your obligation to communicate with attorneys. It's your obligation to make sure your wishes are known. And if you have questions that you're talking about them earlier rather than later, So I'll allow Mr. Barkus to withdraw. I will appoint another public defender. You have the right to a public defender. You do not have the right to a public defender of your choosing. You need to understand that if there are continued issues and it turns out that a new public defender isn't likely to change the analysis, the court can deny you further public defense services if I find that your conduct is the voluntary and functional equivalent of a waiver of the right to counsel. So I'm going to allow the withdrawal. I'm going to appoint a new public defender. You need to be in touch with that attorney when you receive notice who that attorney is. As soon as possible, the case is going to be continued one term. The jury tomorrow can be called off. I think this is the last case on the calendar for tomorrow. So the clerks will spend the afternoon scrambling to try to clear those people so they know they don't need to be here tomorrow morning. New counsel will be appointed. This case will have an elevated priority over the next trial cycle. I don't know if there's any speedy trial claims that have first priority, but this case I'm going to push to the front of the line for everything that doesn't have a speedy trial demand filed in it. Anything else, Ms. Duffy?
No, Your Honor.
Anything else, Mr. Barkus?
No, Your Honor.
Ms. Bush, confirm your address and phone number and email address. All right. So, Mr. Barkus, if you can please file a proposed order. I don't need you to file a motion. The oral motion is sufficient, but if you can get me a proposed order, withdrawing as counsel and appointing a new public defender, the clerk's office will send out a new notice of eligibility, but if you can get me a proposed order so there's something in the file indicating what happened today, that would be appreciated. Anything else, Mr. Barkus?
No, Your Honor. My staff's working on it right now.
Thank you. Ms. Bush, do you understand?
I don't know. I'm gonna get a new counsel and then we're going for the next time that you're available to come in for the jury, right?
So we have trials every month, and usually there's a line waiting for that trial date.
Okay.
Okay, and so tomorrow you were on the very top of the pile. Your case was going to be tried tomorrow. But because of what happened here, we're not going to have a trial tomorrow. I don't know what the line looks at the next time we're in trial, and I don't have that date right offhand, but you'll get written notice of the hearing date, and your attorney will get written notice of the hearing date. There is a way that I calculate who goes first. I don't know who's in line, so if somebody has a case where they've demanded a speedy trial, their case will be heard in front of yours, and that might mean that yours gets delayed again. But your case will jump in front of the line for everyone who has not demanded a speedy trial.
Yes, sir.
Understood?
Why, is there a reason that we are not going to jury trial tomorrow? Like, what is the reason that we're not?
So you fired your attorney. I have to get a new attorney, and that attorney isn't going to be ready in less than 24 hours. So by necessity, because you fired Mr. Barkus and I allowed him to withdraw with your request, another attorney isn't going to be ready for tomorrow morning at 8:30. And so that's why it has to be continued. There's no other choice. So I would prefer that the case try tomorrow so we're not scrambling to address the issue, but that's not going to happen in light of the procedural posture. So the case was continued out of necessity because a new attorney needs some time to prepare. They need time to meet with you. They need time to look into your claims. They need time to subpoena witnesses. They need time to talk with witnesses. They need time to do jury instructions and all the things that the court already ordered done. They're not going to do that in less than 24 hours. So the case is continued. Make sense?
Yes, sir.
All right. Anything else?
No, sir.
This matter is adjourned.
Thank
Have a
you.
good day. Next cases the court is going to take up. State of North Dakota versus David Allen Thompson. 02-2024 CR320. 2024 CR 324, 2024 CR 325. Ms. Duffy appears on behalf of the state on all three cases. Ms. Calling appears on behalf of the defendant on all three cases. The defendant appears personally in court. Good morning, sir.
Good morning.
Ms. Calling, what's the plan today in these cases?
Your Honor, we're gonna move to withdraw our not guilty pleas and enter guilty pleas on all of these cases.
All right. And to all of the original charges?
Yes, Your Honor.
Okay, so we're going to take these one at a time, and I'll start with the oldest first. And then we'll, just so you understand, Mr. Thompson, and so the record is clear, there's some questions that I'm going to ask at the beginning that apply to all of your cases. And then I'm going to ask you about each case individually. And then we'll talk about sentencing again together. Does that make sense?
Yes, Your Honor.
All right. So were you present in court today and at earlier times when your rights were read to you?
Yes, Your Honor.
Do you understand your rights?
Yes, Your Honor.
Do you have any questions about your rights?
No, Your Honor.
You understand that you have the right to plead guilty or not guilty and have a trial?
Yes, Your Honor, I understand.
Okay. And at one point in your case, the court asked for an evaluation from the state hospital to tell me whether or not you were fit to proceed. Do you remember that?
Yes, Your Honor.
And the court received reports saying that you were fit to proceed in all of these cases. Has anything changed since that fitness to proceed report was received by the court?
Not that I know of, Your Honor.
So do you have any questions about what's going on today?
No, Your Honor.
Are you under the influence of any substance or any alcohol, or have you done anything that affects your ability to reason and understand?
No, Your Honor.
Do you feel comfortable moving forward today, that you understand everything that's going on?
Yes, Your Honor.
All right. If at any time you have any questions, I need you to stop me and say, hey, Judge, can I have a moment to speak with Ms. Calling, okay?
Okay, Your Honor.
All right. Do you understand that in all three of these cases, by pleading guilty, you're waiving all the rights that were read to you before?
Yes, Your Honor.
Do you understand that in these cases, you do have the right to a trial, to either a judge or to a jury? In file 325, those are felonies, so that would be a jury of 12. In file 324, that's a misdemeanor, so you'd have a right to a jury of 6 in that case. In file 320, that's a felony, so you'd have the right to a 12-person jury. You understand that all jurors, whether it's a misdemeanor or felony, and whether it's a jury of 6 or 12, depending on whether it's a felony or a misdemeanor,
Yes, Your Honor.
that all jurors would have to agree that you're guilty before you could be found guilty.
Yes, Your Honor.
And you're waiving that right for all of the jurors to unanimously find you guilty.
Yes, Your Honor.
To understand that by pleading guilty, you're waiving the presumption of innocence.
Yes, Your Honor.
To understand that you're waiving in each of these cases the requirement that the state prove you guilty beyond a reasonable doubt.
Yes, Your Honor.
To understand that you're waiving the right to confront and cross-examine witnesses against you.
Yes, Your Honor.
To understand that you're waiving your right to remain silent.
Yes, Your Honor.
To understand that you're waiving the right to testify for yourself.
Yes, Your Honor.
To understand that in each of these cases, you have the right to present witnesses and evidence on your behalf and to use the court subpoena power to force those witnesses to appear, and that by pleading guilty, you're waiving those rights.
Yes, Your Honor.
To understand that by pleading guilty, you're waiving all of the defenses that you could have had.
Yes, Your Honor.
To understand that you're waiving any and all non-jurisdictional defects in the case if there are any.
Yes, Your Honor.
To understand that by pleading guilty, if you do so like you're doing today, not in a written form and not with reserving your right to appeal, that you're limiting your ability to appeal from any of these cases by pleading guilty.
Yes, Your Honor.
Do you still want to plead guilty in all three of these
Yes, Your Honor.
cases?
Still want to plead guilty.
Has anyone threatened you, forced you, or coerced you, or made any promises to you in order to get you to plead guilty?
No, Your Honor.
Has anyone told you that you have to plead guilty?
I do want to plead guilty so I can get this court stuff taken care of.
Okay, has anyone told you that you have to, that you have no other
No,
choice?
no, Your Honor.
Okay. Are you pleading guilty because this is what you voluntarily want to do?
Yes, Your Honor.
And are you comfortable that you know what's going on and you know what you're doing here?
Yes, Your Honor.
And have you had enough time to speak with Ms. Calling about your case?
Yes, Your Honor.
And are you pleading guilty after having an intelligent conversation with Ms. Calling and you're making an intelligent choice based on the advice of counsel?
Yeah, I was talking to her and I told her decide to like plead the guilty for everything
Okay.
and then serve the rest of the days like in the jail so this court stuff can get taken care of.
All right. Do you need any more time to speak with Ms. Calling about your rights, any defenses, your pleas today, and the potential for sentencing?
No, Your Honor.
Are you pleading guilty because there's a plea agreement in place?
No.
All right, so there is no plea agreement in place. Is that your understanding, Mr. Thompson?
Yes, Your Honor.
And you might have heard a sentencing recommendation from the prosecutor. Is that right?
Yes, Your Honor.
And you understand that that is a recommendation. Ms. Duffy will make a recommendation to me, and Ms. Calling will make a recommendation to me, and then I'll ask you for your recommendation. But ultimately, I'm going to decide what the appropriate punishment is, and it might be different than what Ms. Duffy recommends. It might be different than what Ms. Calling recommends, and it might be different than what you recommend. Do you understand that?
Yes, Your Honor.
And you understand that if I do something different than what you expect, that wouldn't be the basis to say, well, that's not what I want a trial. You wouldn't be allowed to withdraw your plea and have a trial if you don't like what I did at sentencing. Do you understand that?
Yes, Your Honor.
Do you still want to plead guilty knowing that?
Yes, Your Honor.
All right. Were you present in court at a previous time when the nature of the charges were explained to you?
Yes, Your Honor.
Do you recall what the maximum penalties are?
I know there was 3 of them, but I couldn't remember.
All right. So we'll talk about those maximum penalties as we walk through your charges.
Okay.
And we'll talk about any minimum mandatory penalties and court fees. Do you remember restitution being a potential for the court?
Yeah, I remember that, like restitutions and.
All right. And how about the potential for immigration consequences if you're not a United States citizen?
He's a U.S. citizen, Your Honor.
Yep, I'm a U.S.
All right. And do you recall that there might be other consequences that happen? We call those collateral consequences, but I'm not required to explain those to you.
Oh, yes, Your Honor.
All right. So we'll walk through each of those cases individually now. I'm going to take up file 324 first because it's the B misdemeanor. So in that case, sir, you're charged with a Class B misdemeanor disorderly conduct. The state alleged that you engaged in a violent, tumultuous, or threatening behavior in reckless disregard of the fact that Ruth Peck was harassed, annoyed, or alarmed, you engaged in violent or threatening behavior on or about November 20, 2024. To that charge, how do you plead? Guilty or not guilty?
Yeah, guilty.
You plead guilty to that count?
Yeah, for that one.
All right. And a Class B misdemeanor has a maximum penalty of 30 days in jail, a fine of up to $1,500 or both. It has court fees associated with it, totaling $250. It does not have any minimum mandatory penalties except for the requirement that you submit fingerprints for law enforcement databases. If your conduct caused any loss or financial harm to another person, the court can order restitution. If you're not a U.S. citizen, it can have immigration consequences, and it sounds like that doesn't apply to you. And it can have collateral consequences for you. Do you understand that, sir?
Yes, Your Honor.
Do you still want to plead guilty to that count?
Yes, Your Honor.
Ms. Duffy, a brief factual basis.
In this case, Your Honor, back on November 20th, 2024, the sheriff's office was dispatched to the courthouse here in Valley City. On a report, they initially made contact with my office, and we had informed them to go check on the clerk's office. They checked into the clerk's office and spoke with one of the deputy clerks, Ruth Peck. In talking with her, they learned that Mr. Thompson had entered the clerk's office. Ms. Peck had approached the window, and when speaking with him, she asked him for his name. At that point, he became angry and punched the protective window in between him and Ms. Peck. Ms. Peck was harassed or alarmed or annoyed by Mr. Thompson's behavior.
Mr. Thompson, is that what happened?
That is correct, Your Honor.
Or is there anything else that you want to tell me with respect to the facts of the offense?
That's exactly what had happened because each one click of courts, they ask what my name is, but then when I ask what their name is, like if I would talk to them like a long time ago, they don't want to give me their name, and then that's when Tanya Duffy was right on that part. That's when I got mad at the lady at the click of court, and that's when I punched that glass window part
Okay,
because I was complaining against someone.
sure. And
So you were there to file a complaint against someone and essentially proved that you're the problem. You punched the glass over her asking you for your name, which she needs for you to file a complaint against someone. Earl, must you? Oh my God. Sorry.
all right. Miss Calling, when this case was first charged, I didn't realize who the victim is, and that poses some concern for me. Are you asking that I recuse on this case because I work in this courthouse closely with Miss Peck?
No.
All right. And Miss Duffy, any conflict of interest on your behalf that you asked that I recuse on this case?
No, Your Honor.
Mr. Thompson, do you understand what I asked the attorneys?
Yes, Your Honor.
Do you want me to send this to a different judge to sentence you on this case?
If you want to, Your Honor.
Well, it's up to you.
Your Honor, if I may, he's already maxed out his sentence in this case. So I think that might help things along.
All right. And so, Mr. Thompson, are you asking that a different judge sentence you? Sounds like your attorney doesn't think that's necessary, but I'm leaving it to you, sir.
Sure,
We don't need a different judge.
No.
Judge Thornton can
No.
handle it. Yeah.
No, Your Honor.
All right. The court accepts the guilty plea and finds that the same is freely, knowingly, and voluntarily and intelligently entered. The court finds an adequate factual basis to support the plea to that charge. Now we're going to move to a different file. We'll move to file 320. In that case, sir, the state charges you with terrorizing. It is a Class C felony. The state alleges on or about November 14, 2024 in Barnes County that with the intent to place an individual with the initials KJ in fear for her or another's fear, or in reckless disregard of causing such fear, that you threaten to commit an act of violence by using a baseball bat on people to crack their heads open and breaking windows at the city court. To that count, how do you plead, guilty or not guilty?
Yeah, guilty for that one.
Okay. And that, sir, is a Class C felony. Class C felonies have a maximum penalty of 5 years in prison, a fine of up to $10,000 or both. The state has not alleged a minimum mandatory penalty except the requirement that you submit a DNA sample for inclusion in law enforcement's databases. Fingerprinting also is something that needs to happen if you're convicted of that offense. The state has not alleged any other minimum mandatory penalties. Court fees for that type of case total $525. If your conduct caused any loss or financial harm to another person, the court can order restitution. If you're not a U.S. citizen, this can have immigration consequences. It might also have other collateral consequences. Do you understand all of that, sir?
Yes, Your Honor.
And do you still want to plead guilty?
Yes, Your Honor.
Has anyone threatened you, forced you, or coerced you, or made any promises in order to get you to plead
No,
guilty?
Your Honor.
Is this what you freely, knowingly, and voluntarily and intelligently want to do?
Yeah, I do want to plead that because I had no right doing that, but I was getting frustrated with the law enforcement because they would pick on me and made threats to damage one of our vehicles, and that got me mad and angry. That's why I had said those threatenings of the baseball bat type thing.
Okay. But do you understand that you have the right to plead guilty or you have the right to plead not guilty to that offense?
Yes, Your Honor.
Okay. Do you need more time to speak with Ms. Calling about your rights, any potential defenses, your plea and sentencing?
No, Your Honor.
Are you pleading guilty because there's a plea agreement in this case?
No,
It's
Your
a,
Honor.
it's a sentencing recommendation, as your understanding, sir.
Yes, Your Honor.
And again, you understand that I'm free to do something different than what's being recommended?
Yes, Your Honor.
Okay. And for this, I just explained the maximum and minimum possible penalties and the nature of the charge. And your plea to that is guilty, sir?
Yes, Your Honor.
Ms. Duffy, a factual basis?
In this case, back on November 14th, 2024, the police department had received a note from the defendant. Within that note, the essence of it was Mr. Thompson was upset, as he had just mentioned, with law enforcement, and he had threatened to use a baseball bat on people and crack their expletive heads open and break the expletive windows at the city court. The note goes on to talk about if they don't leave him alone, that's what he's going to do. The person who had received this, her initials are KJ. She works at the police department. The note that he had left had caused her fear from the way that he had approached and the content of the note in itself.
Well, that's ironic. When you deliver a note to the police department saying that you're going to bash their heads in with a baseball bat, that doesn't get them to leave you alone like you request in the note? Wild.
Sir, is that basically what happened?
Yes, Your Honor.
All right, the court accepts the guilty plea to that charge and finds the same freely, knowingly, and voluntarily and intelligently entered. The court finds an adequate factual basis to support the plea to that count of terrorizing. Moving on to the last file ending 325. Ms. Duffy, there's a confidential information form related to an amended criminal information, but I don't see the amended criminal information. Was one never filed?
There shouldn't be an amended one, I don't believe, on this. I can check my notes, but I don't think anything was amended in the 325 file.
Okay, well, what I was looking at is record 7, or maybe that was just mislabeled as an amended confidential information, not an amended criminal information. Okay. So, sir, in count 1 of the criminal information, the state alleges that on or about November 26, 2024 in Barnes County, that you committed the offense of simple assault by willfully causing bodily injury to a police officer or a correctional institution employee acting in their official capacity, which you knew to be a fact, in that you inflicted bodily injury on Trooper Dustin Pattengale, an officer working in the course of his duties, which you knew to be a fact. That's charged as a Class C felony. Actually, all of these offenses are charged as Class C felonies, so we'll talk about all of the maximum and minimum penalties together. Count 2, the state alleges that on or about that same date that you committed simple assault on a police officer by inflicting bodily injury on Officer Zach Gruba, an officer working in the course of his duties, which you knew to be a fact. That offense, count 2, is also a Class C felony. In count 3, the state alleges that on or about that same date, November 26, 2024 in Barnes County, that you committed the offense of preventing arrest, in that while you were being placed under arrest for a felony, that you employed means justifying or requiring substantial force to effect the arrest. That also is charged as a Class C felony. And so for counts 1, 2, and 3, all of them are Class C felonies. They all have the same maximum penalty, 5 years in prison, a fine of up to $10,000 or both. The state has not alleged any minimum mandatory penalties for these offenses except that you submit a DNA sample and fingerprinting. Court fees for this type of offense or these types of offenses total $525. The court has the ability to impose restitution if your conduct caused any financial harm to anybody. If you're not a U.S. citizen, these types of offenses can carry with them significant immigration consequences. They might also carry significant collateral consequences. Understand all of that, sir?
Yes, Your Honor.
So count one, simple assault on a police officer, Dustin Pattengale, trooper within North Dakota Highway Patrol. To that count, how do you plead, guilty or not guilty?
Yep, guilty, Your Honor.
Count two, simple assault on a police officer, Valley City Police Officer, Officer Zach Gruba. To that count, how do you plead, guilty or not guilty?
Yep, guilty.
Count three, C felony preventing arrest. To that count, how do you plead, guilty or not guilty?
Yep, guilty.
Ms. Duffy, a brief factual basis, please.
In this case, Your Honor, back on November 26th, 2024, the defendant had an outstanding felony arrest warrant for the terrorizing case that the court just went through. Deputy Morton had given information to Trooper Pattengale that about this warrant and how they were looking for a particular vehicle that they believed Mr. Thompson might be in. Trooper Pattengale eventually located that vehicle up at Love's gas station here in Valley City in Barnes County. Trooper Pattengale made contact with Mr. Thompson's brother, Jared Jorgensen, who had stated that Mr. Thompson was in the vehicle and he was in the passenger seat. Law enforcement eventually approached the vehicle, and Mr. Thompson was visibly agitated and did not want to get out of the vehicle. He eventually began to unbuckle his seatbelt and got out. Officer Gruba and Trooper Pattengale then stepped towards Thompson. At that point, the defendant had turned and began striking at both Officer Gruba and Trooper Pattengale using closed fists. Trooper Pattengale was struck in the lower lip. They grabbed a hold of the defendant and he was pulled to the ground. During this altercation, the trooper had sustained cuts on his hand. Officer Gruba had sustained an injury to his back. There was a substantial amount of force that was necessary through the course of this arrest to place the defendant under arrest. Through the course of this, both Officer Gruba and Trooper Pattengale were working in the course of their duties, which the defendant knew to be a fact.
They uniformed?
They were both uniformed, yes.
All right. Sir, is that essentially what happened?
Yes, Your Honor.
Do you have anything else that you want to tell me about the facts?
Yeah, when they told me to get out of the vehicle, heard that it was that I had a warrant out. I was getting arrested from the city court. So I'm making like payments to the city court, and that's where I thought that they had a warrant out, like when they were at the parking lot at Love's. But here it was from the threatening and terrorizing stuff, but that's true.
Okay, so do you agree that when they asked you to get out, eventually you got out, but then you were struggling and you got into a fight with the trooper and the Valley City police officer? In the course of that fight, both of them were injured?
Yes, Your Honor.
And you knew they were cops, right?
Yes, Your Honor.
Okay. Anything else you want to tell me about the facts? Is there anything else you want to tell me about the facts, sir?
No, that's all, Your Honor.
All right. I am going to accept the guilty pleas to counts 1, 2, and 3. Find the same are freely, knowingly, and voluntarily and intelligently entered. The court finds an adequate factual basis to support counts 1, 2, and 3. I'm going to hear, at this point, I've taken guilty pleas in all 3 files. I've taken and accepted guilty pleas in all 3 files. I find an adequate factual basis. Mr. Thompson has previously been found fit to proceed. The court finds that he is interacting with the court in a rational, reasoned way. The court continues to find him fit to proceed in light of the presumption of fitness, the report that has been filed into each of these cases by the North Dakota State Hospital, and the court's own observations of Mr. Thompson in these proceedings. And so what I'm going to hear now is I'm going to hear about your criminal history from Ms. Duffy, and then I'm going to hear Ms. Duffy's sentencing recommendation, and then I'm going to hear your attorney's sentencing recommendation. And then lastly, sir, I'm going to give you an opportunity to tell me anything you want me to know before I'm post-sentence, and then I'll sentence you, okay?
Okay, Your Honor.
All right. Ms. Duffy, first, criminal history.
In this case, Your Honor, Mr. Thompson does have some criminal history. Spans back starting in 2000 for some NSF stuffs. There is false information, some harassment in 2006, disorderly conducts in 2009, as well as disorderlies in 2016 and 18. In 2019, there was a terrorizing adult victim case that he pled guilty to. There was simple assault of a peace officer back in 2020, as well as an attempted violation of an order prohibiting contact. There was criminal mischief out of the city of Valley City from October of 2024, and then that brings us to these three cases. The October 2024 case was in Valley City, where he got upset at somebody at the nearly near the thrift store and kicked their door open and broke the door. For a sentencing recommendation, I'd ask the court to sentence him to 18 months DOC, first to serve 90 days in jail, credit for 61 days actual days served, credit for 10 additional days of good time. So the total number would be 71. A year of supervised probation with the conditions found in Appendix A. If I didn't mention this, I'm just starting at 320 or CR 320. I would ask the court to waive the administrative and facility fees. He is indigent to my understanding, and I believe he also receives either SSI or SSDI.
Can we get this guy some anger management? I mean, just in this hearing, we've heard that he has punched a window, threatened to crack skulls with baseball bats. He's kicked in doors. This guy needs some professional help.
I would ask the court to impose a $25 victim witness fee on CR 320. Moving to CR 324, 30 days of jail, credit for 30, no probation. And I'd ask the court to waive the admin and facility fee and impose the victim witness fee. On CR 325, 18 months DOC, first to serve 90, credit for 61 actual, 10 plus 10 days of good time, so a total of 71. Another year or a year of supervised probation with conditions found in Appendix A. I would again ask the court to waive the admin and facility fee and impose the victim witness fee. So those total fees the state would ask for is $75. He does have $400 worth of bond posted. So I'd ask that that be applied and the remainder to be refunded to the remitter. On CR 325 for counts 2 and 3, just the same 18 months DOC and supervised probation as outlined in Cal 1.
All right. Miss Colling.
Your Honor, essentially what we're asking for in the felony cases is a 360 days to the Barnes County Correctional Center with all but time served suspended. So essentially we're asking for a misdemeanor by disposition. I understand that's probably a lot to ask, but it seems to me that he was going through a very rough patch because all of this seemed to happen within about a 2-week period of time. So I don't know what was going on with him. We thought he had maybe some issues. That's why we did the evaluation at the state hospital. But since he's been on probation while he failed to appear in court, there's been no additional new charges. So to me, that's promising. So we would ask for 360 days, Barnes County Correctional Center with all but 71 days suspended, credit for the 71 days already served, 1 year of supervised probation on Appendix A terms and conditions that this court feels are appropriate. We agree with the waiver of the mandatory fees except for the $25 victim witness fee in each of the cases or files. My client is financially indigent. He survives basically on, is it Social Security disability or just SSI?
SSI and SSDI, that's my mom's money.
Okay. He does live with his brother and his brother's husband here in Valley City. He does have an elderly dog that he is responsible for. And with his brother in his living situation, they split up the household chores and they also split up the bills. So, you know, they are in need of my client's financial contribution to the household finances. So we believe that that would be an appropriate sentence for the felony cases.
And then for the misdemeanor, we would just ask for a 30-day straight time sentence credit for 30 days already served.
All right. Mr. Thompson, is there anything that you want to tell me before I impose sentence?
No, Your Honor.
All right. I'm going to start with file 324, the B misdemeanor. The court's considered the general purposes of the criminal code and North Dakota Century Code section 12.10102. The court's considered the sentencing factors in 12.13204. The court's considered the amount of jail credit the defendant has on this file already. And so in this case, the maximum penalty is 30 days in jail. The defendant has more than 30 days in jail credit actual. The court's sentence is as follows: 30 days in the custody of the Barnes County Sheriff to be served at the Barnes County Correctional Center. Credit for 30 days actual, concurrent with file ending 325 and 320. Fees, all of the fees waived. Moving on to file 320. This is the city court case. The terrorizing involving city court. Sentence will be as follows: 18 months in the Department of Corrections and Rehabilitation. First to serve 71 days. Credit 71 days. And that's first to serve 71 days in the Barnes County Correctional Center. Credit for 71, of which 61 is actual. 10 days good time. Balance suspended for a period of 2 years. 2 years supervised probation. Fees waived. Standard conditions of Appendix A. Special condition: the defendant to obtain a diagnostic assessment from a regional human service center and follow through with any treatment recommendations from the regional human service center while on probation, concurrent with file 325 and 324. Moving to file 325, count 1, 18 months, Department of Corrections and Rehabilitation, first served 71 days, Barnes County Correctional Center, 61 days actual time credit, 10 days good time credit, sentence reduction credit authorized by law, 2 years supervised probation, balance suspended for 2 years, fees waived, special condition diagnostic assessment from a regional human service center, follow through with any treatment recommendations from the regional human service center, concurrent with 324, concurrent with 320, same sentence on 1, 2, and 3. Ms. Duffy, Trooper Pattengale, and Officer Gruba are not asking for restitution, correct?
Correct, Your Honor.
0 restitution, and no physical damage was noted or any loss or financial or pecuniary harm in the other 2 files, correct?
That's correct.
All right. So no restitution in any of the cases. I'm waiving all fines and fees. The $400 bond will be refunded to the bond remitter due to the defendant's, frankly, extreme indigency. That money will come back. All sentence reduction credit authorized by law. Again, 10 days good time credit applicable in the felony counts. 71 days total on all the felony counts. So what that means, Mr. Thompson, is I'm not putting you in jail any further because I don't think jail is going to accomplish any criminogenic goal or purpose. But I am putting you on probation for a longer period of time.
Okay, Your Honor.
And as a condition of probation, I'm requiring you to get another evaluation from a regional human service center. So that's probably South Central Human Service Center. They're based in Jamestown, but they have a satellite office in Valley City. And you need to follow through with any treatment recommendations from them, because I think that your mental health concerns, and there are some, affect your ability to function in society, and I'd rather have those treated, and I just don't think a jail is going to treat those for you. But you do have to follow through with any recommendations that your evaluator provides. And so if that means medication, if that means anger management counseling, if that means cognitive restructuring, whatever that means, whatever they recommend, you need to follow as a condition of probation. If you don't, state can ask the court to revoke your probation and resentence you up to 5 years on each of those counts and send you to prison. I'd rather not do that, Mr. Thompson. I'd rather get you the help that you need so I don't see you back in my courtroom again, okay?
Okay, Your Honor.
Do you have any questions about what my sentence is?
Yeah, when you mentioned about the South Central, there's no trespassing on the satellite one. So I would have to go to the Jamestown office for that South Central.
Okay, well, they can figure that out.
Okay.
They're the regional human service provider, and so That needs to be accomplished somehow, and your
Okay,
probation officer can help you with that. Okay?
okay,
So if you haven't had your DNA sample taken or your fingerprints taken, you'll need to do that within 7 days. And if you have any questions, you'll need to report to probation within 24 hours, sir. So you should do that today if you can.
okay.
All right? Do you have any other questions?
No questions, Your Honor.
Ms. Duffy, did I miss anything?
No, Your Honor.
Ms. Colling, did I miss anything?
Do you have a little card with the contact number or contact information for parole and probation? Okay,
Yeah.
we'll get
So
you that contact information so you can call them today.
Ms. Colling will get you that card so you can report to probation today.
Okay,
And you need to do that within 24 hours, okay?
okay.
All right, with that, we're adjourned in these cases. Have a good day and good luck to you, sir.
Yep, thanks, Your Honor.
All right,
Thanks.
Thank you, Your Honor.
with that, we're adjourned.
That was wild. Absolutely insane. That first woman wanting to fire her lawyer the day before her trial, and then whatever the hell that was. Yep, same here. Absolutely same. All right, guys. I'm gonna go night now, so I can get up and do it all again tomorrow. Maybe tomorrow I'll have furniture in here, or at the bare minimum, curtains. Thank you guys so much for coming out and hanging out with me. Be safe, be well, sleep sweet, and much love.